Are we good to go? Okay. Good afternoon, distinguished attendees. Welcome to the Nigerian Bar Association SBL weekly. And we have the season 3, episode 1, taking place today, titled Third Party Funding under the Arbitration and Mediation Act 2023, the Innovation, Opportunities, and Handmaidens. Now, before we proceed, I'd like to briefly introduce the host for this event today, Mr. Ladipo Shoeton, the Fellow of Chartered Institute of Arbitrators, who is a managing partner of CG Shoeton & Co. He's a 1987 graduate of the law from the Bafemi Awolowo University. Mr. Shoeton holds a master's degree in law from the University of Lagos and is a member of Chartered Institute of Arbitrators, BRIPAN, as well as the Nigerian Bar Association. He's had over 35 years of experience in extensive commercial dispute resolution. He's regularly advised large operators in the Nigerian oil and gas industry and is currently a distinguished chairman of the Arbitration and ADR Committee, which is the host for this event today. Permit me to also introduce our speaker today, Mr. Godson Ugochukwu, Senior Advocate of Nigeria, Fellow of the Chartered Institute of Arbitrators. Mr. Godson Ugochukwu is a distinguished legal practitioner with a celebrated career spanning over 2 decades in commercial dispute resolution and advisory services. He was elevated to the rank of Senior Advocate of Nigeria in 2022. His expertise is not confined to the courtroom. Godson is also a highly respected international arbitrator and mediator, known for his fairness, profound understanding of the intricacies of arbitration, and so on. Beyond his notable legal and arbitration practices, Godson is actively involved in the global community through his membership in several esteemed organizations, including the African Arbitration Association, the Chartered Institute of Arbitrators, and SPLA. He is also a regular invitee to various events where he speaks. He is a committed family man and the founder and principal partner at Fortress Solicitors, a full service law firm and one of Nigeria's leading service providers. Welcome, Leonard Silk. So at this point, I'd like to welcome, sir. So at this point, I'd like to hand over to our host, Mr. Ladipo Shoeton, Fellow of Chartered Institute of Arbitrators, to give his opening remarks before we commence the session. Thank you. Over to you, sir.
Thank you very much, Amara. Thank you. Good afternoon, distinguished ladies and gentlemen. It's my pleasure to welcome you all to today's webinar entitled Third Party Funding, Innovations, Opportunities, and Handmaidens. This webinar is organized, as you know, by the section on business law. And as we all know, this section of business law is one of those special sections, especially to engender the professional development of Nigerian commercial lawyers and thereby raising the level of business practice in the country. The section has at its apex a council which is currently chaired by Dr. Adeoye Defulu. The Arbitration and ADR Committee, of which I'm chair, is one of 26 sector-focused committees established to cover existing and new areas of commercial law, with a view, as I said, to enhancing commercial law practice among Nigerian lawyers and law firms. One of the objectives of the SBL, is to promote the study and development of business law in Nigeria, and this includes providing a forum for legal practitioners to discuss emerging issues, participate in training and capacity building, and to contribute to policy formulation in areas relevant to business law. For those of you who may be joining us are not members of the section, membership is open to all legal practitioners who are members of the Nigerian Bar Association and have an interest in business law. Members may be in private practice, maybe in-house counsel, academics, or other professionals involved in the practice or study of business law. The SBL organized various activities throughout the year, including conferences, seminars, workshops, and training programs. This is one of them. And we also publish journals, newsletters, and other publications to promote the activities of the SBL and develop capacity. We also, as the SBL, engage in advocacy efforts to promote legislative and regulatory reforms that enhance the business environment in Nigeria. This can, obviously be seen with the new Arbitration and Mediation Act, which we are discussing today. The SBL is very, very much involved in the promulgation and the passing of this act. Now, before we delve into the increase of third-party funding, allow me to take a moment to welcome a very distinguished member of the Nigerian Arbitral Committee in the person of Professor Dorothy Ufote-Essien. Welcome, ma. You here? I would also like to welcome Mrs. Fumi Roberts, a very respected former chairperson of this committee. I think she was chairperson between 2011 and 2015. Very glad you could join us today. I'd like to, of course, welcome and thank our esteemed speaker, Godson Ugochukwu, FCI AB SAN, who is also a member of the Arbitration and AGR Committee of the SBL. As Amara has said, Mr. Ugochukwu is a distinguished figure in the legal profession and is renowned for his expertise and contribution in taxation and dispute resolution. Without further ado, I invite you all to join me in welcoming our esteemed speaker as we embark on this enlightening journey into the realm of third-party funding under the Arbitration and Mediation Act. Thank you very much. Amara, back to you.
Thank you very much, Mr. Shoatong, for your opening remarks. So I'm going to move to the learned field, and
I can hear you.
Very well, sir. So learned field will take some baby steps before we delve into the technical aspects of third-party funding today. May I comment by asking you what third-party funding is under the Arbitration and Mediation Act 2023, and what is the difference, if any, from maintenance and champerty?
All right, thank you so much. Thank you, Amara, for the kind words and introduction. And to my chair, I'm very grateful for the opportunity. And I welcome every one of you to this chat. Hopefully, we can do justice to the topic. To your question, Amara, I'm not aware that the Arbitration and Mediation Act actually defined funding, which henceforth I'll refer to as TPF. But generally speaking, third-party funding is, as the name basically explains, a third party is a person who is not involved in the subject matter of the dispute. It doesn't have privity to the contract. It's not part of the dispute at all. So third-party funding is when a party to a dispute, in most cases the claimant, seeks financial aid from a person who is outside the realms of that dispute in order to be able to finance the claim itself. All across the world, this is just the pedestrian layman's, if you like, or the most simplified definition of it is what I've just given you. All across the world, outside of our own jurisdiction, you find that it is actually an existing industry, fairly well, depending on the jurisdiction you're talking about. If you go to varying degrees. So for example, in the UK and mostly in the US, it's much more developed. You have legal financing companies, and they do not just extend to arbitration, they extend to litigation. So as far as definitions are concerned, the third-party funding is when you obtain financing or financial aid from a third party who is not involved directly in the dispute. Under the AMA, as we all know, and any practitioner of arbitration would know what a seminal development the Arbitration and Mediation Act of 2023 is. We can't say enough about the innovations and the impact it's had on the practice of arbitration within Nigeria and indeed across the world. Its innovations resonate. Section 60 of 61, if you like, has banned, if you like, has bifurcated, kind of sliced off the realm of arbitration from the effect and application of Shampati and maintenance, and thereby legalized TPF within Nigeria. Now, you did ask what Shampati and maintenance is. Both are usually used together, maintenance and Shampati, but they are not exactly the same thing, although they are two pies in a pod, if you like. Maintenance itself is when, for want of a better expression, you have a person plays cheerleading role for disputes, for litigation, for an ongoing dispute. The person is on the sidelines, he's egging people on, one of the parties on, to continue and not give up. They do not have any interest in the outcome of the case, but they just want the matter to keep going. That's the thought. It's a common law. Is a common law origins, is the thought of maintenance. Shampati itself is maintenance with beneficial interest, with an interest in the outcome. So ordinarily, TPF would be considered Shampati maintenance, because the Shampatos individual or party has an interest, has something to gain from the outcome of that litigation or dispute resolution process, is interested in, egging the parties on and in the hope of the outcome. So that's the difference. And the one significant that the AMA has done for us is to carve out the space of arbitration and legalize TPF. At Shampati and maintenance do not apply.
Thank you very much, Leonard Silk. Now, in the spirit of celebrating these innovations, like you discussed, surrounding third-party funding, the AMA, let me take you back a bit to the status quo of third-party funding in Nigeria. So, what exactly was the status quo on third-party funding in Nigeria? I mean, before the Arbitration and Mediation Act, and how has the Act changed that?
Okay, so again, I'm sure that probably the answer, you would have caught snippets of the answer in my previous comments. Before the advent of Section 61 of the AMA itself, we did not have this legalization. The thought of maintenance and Shampati spread like an umbrella over everything that could be considered third-party funding. And as you well know, or as you may know, one common thing that happens, especially in the world of litigation, but also maybe to some extent within the space of arbitration, is that sometimes lawyers do this contingency fee arrangement. In a very loose form, that in and of itself is third-party funding, because the lawyer, but he has decided, he or she or the law firm has decided to take on part of the cost in order to allow or to enable the claimant gain access to justice and to be able to litigate that particular dispute. I have no doubt that it also have, not in my experience, I've never experienced that, but I have no doubt that it also happens in arbitration. And usually you will find that that's a question of reviewing the strength, do a SWOT analysis on the case, reviewing the strength of it, and then if the individual or the law firm or the lawyer is convinced that there's a good case, then they take on the matter on a contingency fee basis. Depending on how they choose to slice and dice it, you will find that the lawyer may throw in money, or maybe just be a question of deploy money's worth. That generally would fall within the realm of maintenance and Shampati, although there are some old case laws that if you look into all that, there seems to be a bit of controversy as to whether that will qualify as maintenance and sham party. But suffice it to say that TPF was not acknowledged as legal in Nigeria. Okay, and that practice, the most you can find, the most approximation you can find to that practice would be in, as I have described it now, in continuous fee billing. So you can now understand what a momentous decision it development is.
Indeed, learning should. So you had mentioned, speaking on the innovations the AMA has created here in Nigeria, you had also talked about the development all over the globe, which we believe must have definitely inspired the legalization of third-party funding in Nigeria. So would you want to comment on the status of third-party funding across the globe? Other arbitration communities in other jurisdictions?
Yeah, thank you. So again, this is one of the things that, for me, shows what an important development the Arbitration and Mediation Act 2023 is. Because we come from a region of the world where we are happy to pick up the trail of the rest of the world. We're last almost in everything. But you find it interesting to discover that third-party funding is still an evolving concept all across the globe. Up to date, even in certain if you like, where you would think that such issues and such topics are settled and the market is well developed, there's a robust, all the contours are well defined, and it's easy. It's not. In the UK, up until as far back as just as recently as February 2024, the UK Parliament was still rolling out, making plans to roll out legislation to reset the apple cart based on a decision that suddenly, the Parker decision that suddenly set the cat among the pigeons as far as settled issues of third-party funding were concerned. So it's an exciting thing to say that, for me, it's very important that we have in mind that Nigeria, Section 61 and Section 62 of the Arbitration and Mediation Act pivoted Nigeria into only the third country in the entire world, following Singapore and Hong Kong in 2017, that have codified the practice of third-party funding. This is not to say that it is non-existent in the rest of the world. In fact, of course, in the UK, it's well established, but it's still evolving, as it is in the US. In fact, in the UK, actually, I understand that it's between 1.5 to 4 billion pounds business per year. And so in the US, it's also a multi-billion-dollar business. But you see that even countries, there's a competition. Part of third-party funding is one of those things that countries that are looking to position themselves as favorite arbitration seats. These are things that they focus on and to legitimize and evolve rules that will make the rest of the world attracted to them. So, for example, Singapore, and then you have Hong Kong. Singapore and Hong Kong actually are always, as it were, going head to head, trying to, in Southeast Asia, to compete with one another in becoming the beautiful bride of as an arbitration seat. So at the world, I'm happy to say that what we are doing, what our attempt, we are bringing up the rear, yeah, in some area of aspects of it, but generally speaking, it's still an evolving concept across the world. And I'm happy that Nigeria has taken the bold step that it has. Back to you.
Thank you very much, Leonard. So we've spoken, you've spoken like a typical arbitrator. So now I want you to speak as a funder. Now, we all know that for every businessman, there's always the excitement with generation of profit and the return on investment. So let's talk about third-party funding from the side of the funder. Now, clearly, TPF is a form of investment. By the funders, and like all investors, the primary interest is the return on investment. Now, how can funders legally safeguard this investment and guarantee a return on investment.
Thank you, Amara. This is a very important point. In fact, for me, as far as I'm concerned, when you look at this innovation itself, and your question is one of the more important issues that we need to dwell in, not just in this chart, because we can't possibly do justice to it, but it is one thing that the innovation has done that should resound across the terrain. What the Arbitration and Mediation Act has done is, in my view, to birth an industry. So first, it has created the legal financing industry and legitimized it in Nigeria. If there was anybody doing it before, the person need no longer hide under the table. That being said, to the kernel of your, because it's an investment decision. It's no different from going to a bank to borrow money. So at the end of the day, the bottom line is what the person must look at. So it is important that a funder, and we're just skimming off the top because there's a whole lot that would go into the decision as to whether to fund or not fund. But suffice it to say that what the lawyer would do in order to decide whether to adopt a contingency fee billing is what the funder ought to have their eyes on because of return on investment. You have to do a SWOT analysis on the case. You have to look at it critically and look at the strength of it. That is one. Given that this arbitration, the seat is important because the case might be good. It might, quote unquote, be an open and shut one, but you would need to enforce. And the seat is everything as far as enforcement is concerned. So you want to look at the legal system of the seat and how efficient it is. So the mere fact that an arbitration concerns, as you well know, two maybe local entities, two Nigerian parties, does not necessarily mean that the seat will be Nigeria. These are the things that we have to look at. I would also go as far as saying that if enforcement, if you have an eye still on the issue of jurisdictional considerations with regard to enforcement, if, for example, you plan to enforce in the UK, you take a second look at the TPF, at the third-party funding agreement, because of the recent decision in Parker, where the UK Supreme Court came out to basically render almost all litigation funding agreements pre-existing until the date of that decision, rather than illegal, because unless they comply with the because they consider them to be damages-based agreements, and they must comply with the damages-based agreements regulation of 2023. So 2013. So that itself has completely changed the face of third-party funding agreements across the UK. If you are looking to enforce there, you must look at all those things. So just a quick summary. One, you have to look at the strength of the issue of enforcement, and amongst other things, look at the length of time it will take. Okay. And then if I were speaking as a funder, I'll be looking at also who are the persons who are going to litigate the matter. For example, your choice of counsel. Okay. And the good thing is that recently the IBA guidelines on conflict of interest, with regard, as far as it concerns third-party funding, has law is not binding, but it has recommended that, look, even third-party funders can have a leverage to the extent of even deciding who the choice of counsel. So these are the issues that they will have to look into. And I'm sure that you can begin to see, much more importantly, how this development will help the practice of law in Nigeria, because all those things I've touched now, most of them are things that you will need a lawyer to come in and do. So that further deepens the market for us.
Thank you, Leonard. You have laid emphasis on the SWOT analysis on the part of the funders. You talked about the seat of arbitration. It's important. You've also talked about ease of enforcement, the time management, and most importantly, the experience and expertise or reputation of the counsel representing the parties. But I think we all know, I mean, most arbitrators here would agree with me that, you know, the theoretical knowledge of arbitration is way, way different from, you know, the practical experience that you find when you delve. So I want to take you back to AMA, a little bit into AMA and the certain provisions in AMA for us to, you know, for you to share your experience with third-party funding. Now, clearly, the AMA section 50 sub 1 of the AMA provides for recovery of costs in arbitration, and this covers third-party funding as well. Now, but that may not exactly be as simple as it sounds. Like I said, it's easy for us to speak about it theoretically, but in practice, it's usually a different ballgame. Now, what issues do you foresee? And have you ever been in a scenario where you've had issues with you know, the whole drama with third-party funding and counsel parties? And how were you able to manage these issues, if at all you have been in a situation where they have arisen?
So thank you. Personally, I haven't engaged with this issue in my arbitration practice or an experience, but I can give you a few instances and some of the things that have come up in other cases across the world. So Section 50, you're correct, of the AMA has given a list of the costs that are recoverable. Generally, it's the same principle in arbitration that all arbitration costs are recoverable. But in this case now, AMA had also added the cost of third-party funding. When you look at it and skim off the top, it looks simple, the cost of third-party funding. The question is, what is the cost of third-party funding? What exactly is the cost of third-party funding? The cost of third-party funding would be the benefit to the party. So I give an example. You are looking to recover 200 million, and you have a third-party funding arrangement with, say, Shueto LLC, and the agreement is 40%. Okay, I'm using 40% because the EU currently mulling the question of third-party funding across the EU. In 2022, the VOS report came out, and one of the recommendations is that they should cap how much on investment third-party funders should receive, no more than 40%. It's yet under discussion. But let's say it's 40%, and you recover 200 million. The quarter, but you know that you take 200 million, you're going to pony over 40% of it to the funder. That cost, there have been decisions to say that that is the cost of third-party funding. That is actually the cost of it. Therefore, it should be factored in by the panel in making the award. This has happened. There was the situation actually that happened in a case in Hong Kong that eventually led to Hong Kong legitimizing third-party funding, UNRWA and CBERGER. That particular uplift was the controversy because the arbitral award tribunal awarded it, and an application was made to set it aside on the basis that the tribunal exceeded its mandate. And the court found that that cost was legitimately incurred and awarded. So that's one issue. I think it also did come up in ESSA and NOSCO in the UK. So these are the issues that would come up. Okay, and it should be interesting to see how Nigerian courts, if it ever gets to Nigerian courts, engage with it. Hopefully, also the arbitration tribunals, as we begin to engage with that issue, will also develop our own body of jurisprudence on it. But as far as I'm concerned, I think that as far as that question of cost is concerned, that is, it should be. So you have that cost, the award itself, the capital investment, and then the return on investment, the agreed uplift. I don't know whether that addresses your question.
Yes, please. Thank you very much, Leonard. So from your previous discussion, you have highlighted, indirectly highlighted one silent disadvantage surrounding these innovations. For example, the third-party funding, which we are currently discussing, especially when you talked about the deductions from deductions of profits by the funders. Now, would you agree that there are actually downsides to this innovation? I mean, speaking of third-party funding, and what example with third-party for example, with third-party funding increase the demand for security of cost in arbitration?
I imagine, yes. So for every, obviously, it's, I mean, in the clash of human interaction, every benefit definitely would have some disadvantage to it. Whether foreseen or unforeseen. The good thing is that in our space as lawyers and arbitration practitioners, what is unforeseen eventually, as we continue to engage in it, we also, human beings are quite nimble. We also develop ways to cope with it. One thing I see easily, and I do not lay any claims to clairvoyance, but the one thing I see that is very likely to happen is the question of adverse costs. Okay, it's easy to imagine that a claimant approaches a third-party funder, makes the arrangement, gets the funding that they need. All of things have been discussed, and most of the time, every time TPF is discussed, it's usually in the context of, would you be able to recover, and how much can you recover? Okay, knowing full well that third-party funding is a non-recourse debt or loan. The entirety, it usually does not come with any collateral. The entirety of expectations, it's summarized and circumscribed to the amount that will be covered. So you're hoping that the case is successful. Now, the upshot of it is that if the case is not successful, there's no money that will be recovered, right? But this is arbitration. If you lose in an arbitration, you are at the very least liable to pay the costs of the other party. So that's what we call adverse costs, as you know. The question is, what happens? Who bears adverse costs? Okay, so that is one thing that would likely happen. And I think that the arbitration, the AMA, that's one thing that I'm not quite sure that AMA has provision. I can't quite recall that there's a provision on that right now. The second issue is whether, like you did mention, will it trigger an application for security for costs? It is very likely. And because it's, in fact, it's one of those low-hanging fruits in terms of if you are picking at what could happen, what it could trigger. The AMA has provided for that. Okay, that it's, if you look at, I think it's section 50 sub 1 sub C or so, there's a provision that if the provision requiring disclosures, once you make that disclosure, the immediate suggestion is, oh, this person cannot fund their arbitration. And if they cannot fund it, how can one be confident that they can pay my cost if they lose? And so there might be the requirement for security for cost. So yes, a short answer to it is yes, I think it can trigger that. And the AMA has graciously provided a solution to that. You can depose on affidavit if there's if that disclosure is made and the counterparty brings an application for security for costs, the funded party can file an affidavit disclosing whether or not that arrangement, the TPF arrangement, covers adverse costs. What it simply means immediately is that the AMA is recognizing that that question of adverse costs can be a question of contract. So that when you are obtaining the funding, part of the funding contract could be that you will have to extend it to adverse costs. And so if the funded party files that affidavit making that disclosure, it is not ipso facto binding on the tribunal to accept it, but the AMA provides that it should be one of those things that the tribunal should take into consideration in making a decision as to whether they will order security for cost or not. So I think that is for me, that's a good way to go about it. And one more thing that I want to say on that provision, why that provision I'm excited about it, is because it preserves the confidentiality. It struck a fine balance between the need for confidentiality and the need to assure the counterparty as to give the confidence, necessary confidence and comfort regarding adverse costs. So yes, I think that it will trigger adverse costs. It's very likely to do so. If I were acting for a party that has where the counterparty has TPF, I would ask for adverse costs.
Let me ask.
Okay, please go on.
Leonard Silk a question, and I know you're speaking now to us as well. You're an arbitrator also. So, what I would like to ask is, this is still not set in our jurisprudence, but what considerations would you recommend or suggest that an arbitral panel consider when deciding whether or not to grant an application for security for costs, whether or not the affidavit has been filed? Because what is important is that the respondents have some reasonable expectation that those costs will be recovered. Now, an affidavit saying that, for example, that those costs are not covered by the third-party funding agreement, would that be sufficient? Would that be enough to allow the arbitral panel to make the decision, or would there be more required? And for example, with the great respect, what if the affidavit is how shall I put it, not entirely accurate as to the specificity of what is what recourse would the respondent then have, because affidavit is not money.
So, interesting point you raise, Mr. Chairman, interesting point. But so first, to the affidavit, right? Affidavit is a statement on oath, as you well know. I would be shocked to find that a person who is best positioned to issue that affidavit, meaning, let's say it's the claimant that obtained third-party funding. You are familiar with your TPF agreement, and then you depose an affidavit. You know very well that, let's say it doesn't cover it, but because you want the arbitration to proceed, you depose an affidavit and say it covers it. That's perjury. So you've donated a proceeding, a quasi-criminal proceeding in perjury to the other side or the other party. And I think that's what the makers of the AMA, in articulating that particular provision, that must be what they had in mind. That is one. The other thing is, it's also good that the provision did not just say that the moment you file the affidavit, just throw in an affidavit there and the hands of the tribunal are tied. I think that if I were sitting as a tribunal member, or whether as a sole arbitrator, and this application comes before me, there are a whole number of other things that you may want to look at. Because first of all, looking at the quantum, okay, I've just made the comment now that the AMA tried to strike an interesting balance between preservation of confidentiality of that TPFA and also having given this comfort. But maybe the arbitral tribunal could, on their own, without compelling the party to make further disclosures, you look at the surrounding circumstances, look at the quantum, and then make a decision. But I think that it will be difficult to navigate away completely from that affidavit that is deposed. The affidavit is very important. And much as the act itself uses rather understates mild statement in saying it will be relevant. It will be a relevant document to consider in coming to that decision. It is actually pivotal. It's highly important, especially given that it is issued on a head of potential criminal prosecution. So I would look at the entire quantum of the claim and probably ask for more facts from the parties. But again, a lot will have to depend on the affidavit.
Thank you very much, Leonard. Mr. Sure, I hope that
yes, Amara, thank you. I yield.
I hope that settles you.
No, it was just for the purpose of you know, not debate. I'm not debating it with him, but for elucidation. You know, I mean, we had spoken about this offline, myself and the Silk.
Yeah, we did.
And I just wanted us to, you know, touch on it.
Bring it to the table.
Yes, exactly. Exactly.
And speaking of tables, Leonard Silk, I'm about to pull you to another very interesting table. But before I do so, may I ask our distinguished attendees to kindly drop your questions? I see questions already coming in. Please drop your questions in the Q&A section, and once we're done, we're going to take your questions as much as we can. So speaking of the table, I want to pull Leonard Silk to a very interesting table. Now we've talked about innovations and advantages, disadvantages surrounding these innovations. But I want to pull you to a table that, of course, we have most practitioners sitting on, and that's the opportunities for legal practitioners, arbitration practitioners, lawyers, acting as counsel, other practitioners, and other sectors in the economy. What are the opportunities that these innovations will likely, create for us all?
So the very first one that will jump at anybody is, especially given our discussion, if you're anybody following our discussion, and then if anybody who's bothered to read up a bit on TPF, is the role that for lawyers. There's a whole lot that lawyers would have to do if this industry becomes a thing in Nigeria. First, we've talked about case review. If any funding party, any funding company or entity or individual wants to fund, naturally, they would want to have the case, have a lawyer who is bound by confidentiality, by even the very virtue of our practice, review the case and do an analysis. That is work for the lawyer. That is money for the lawyer. Beyond that, let's say they have decided that they can go on. And I tell you what, in that review, some may decide to get a second opinion. So the more, the merrier. That's one. Secondly, drafting. One side would draft. That's work for the lawyer. There will still be a question of reviewing the drafts by the other side. That is still work for the lawyer. So there's a whole lot that we can do in it. And then you now come to also the issue of course, the traditional role of representing parties, right? And you know that the more, one thing it will do, one of the most important things that this will do is to elevate our practice in terms of competence. Because the beauty parades will be more now. You have to show competence. You want to attract business to yourself. So you see, because of the fact that the funding party is very likely, I mean, I'll be surprised if the funding party, especially in big ticket transactions, disputes, a funding party would actually want to have an interest in who represents. Because the lawyer, the counsel that is appearing for the funded party is actually there, but most importantly, appearing for the funding company or entity. So that's very important. The other thing too is that the claimant might have the freedom to choose its own lawyer, but the funding party might want to add one lawyer or two, to the team. So it seems to me that it's a win-win on every front for lawyers. It deepens our practice, it elevates it, it puts grants opportunity for more work, and greater, more importantly, or for greater specialization in the space of arbitration for all of us. Did you ask about any other industry? I can't remember. I think you're muted.
You're muted though.
Leonard Phil, thank you very much. Let us see, before I let you go, I want to quickly, so you've touched quite a lot with the limited time we've got, and I know that there's this debate surrounding third-party funding. I mean, people would ask the question: is legalization and codification enough? So I want you to please share some practical tips or best practices for parties considering third-party funding for arbitration in Nigeria.
So I think, you know, when I read it or looked at the topic and handmaidens, I think these are, I feel that obviously the short answer is the question of, is codification enough? It's not enough. And I don't think that the parliament intended to say, there, you have it. Now go practice third-party funding. It's not enough. There'll still be a whole lot to be done. Consider codification as buying the empty, undeveloped land. Okay? We have to dig the foundation. We have to, and these are the things that some of the issues that we've touched on here are the things that would now help us to develop the lay of the land. What codification has done is to tell us that we've now taken this thing, sliced it from the realm of illegality or the specter of it, to bring it to the daylight of proper legalization. But especially for funding companies, it's very important that we roll out, there should be the necessary regulation or regulatory guidelines. If you look at the UK today, most of the boundaries set for funding companies have been as determined by court decisions. You know, in some other countries, there are guidelines. India, I think, is considering one, Hong Kong, Singapore. Currently, the EU had made reference to the VOS report of 2022. You know, they are moving it. The same thing, I think Ireland too is discussed. So where we are, as far as the guardrails and the guidelines and regulations of that industry, the funding industry is concerned, Nigeria is not lagging behind at all. Okay, we are right now at where most, even people that consider to be advanced economies, a lot of them are. Okay, but what is important is that guidelines and guardrails need to be developed. We need to decide to what extent can a funder influence the process. Again, I give you an example. In fact, for me, what I would recommend would be the VOS report, not to adopt it wholesale, but it does contain quite a number of interesting and innovative ideas to circumvent certain problems that will come up from third-party funding. So, for example, the issue of capping how much the funder can receive. They are recommending that they be capped at 40%. In fact, the question of adverse costs, the VOS report says there should be a policy decision making the funder obligated to share adverse costs with the claimant. Okay, so whilst the AMA seems to be suggesting that it should be a matter of contract, the VOS report is making it a matter of policy. So the whole number of things, again, you talk about, should they have, for example, minimum capital deposit, maybe with the central bank, you know, to be able to roll out a product called litigation or arbitration funding. You know, so these are things, but I'm sure that the most important thing is we have the land, and we can now slice and dice as we see fit. Thank you.
Thank you very much, Leonard. We have so many questions for you, and hopefully we'll be able to take them as much as possible. Thank you very much. This is a full lecture, and for those who still want to reach out to Leonard, you can always catch him on LinkedIn or send him an email. find him asking more questions. I'm sorry, we really have to run. We have to take a few questions, and we have just 10 minutes. So let us see. I'll try as much as possible to cover all the questions. We can try to, manage to keep the answers a bit brief. So I'll start with the first question. This is from Ezebu Ejikeme. Let us see what, in your view, should be done regarding ethics to protect the system from abuse of prioritizing profits over fair administration of arbitration justice.
Well, a very important point. It's the same thing that everybody is chewing on. Every jurisdiction is grappling with it. Okay. Again, it's about, we have to, as we begin to practice it, have to evolve a robust body of ethics to that product, but that practice. But obviously, this question goes more to the side of the funders, and it still draws a straight line to my previous comments on the need to evolve guidelines and guardrails to define contours of this thing and set boundaries for that. It is still a nascent development. We really don't have that industry currently, but I do think that legislative intervention, whether by way of giving, further expanding the role, maybe you say the central bank, or every time I think about third-party funding, I think about BOFI companies, the banks and other financial institutions, because the moment they come in, that will deepen it's not about any random person just saying, okay, I have the money, I can fund it, because once those regulated industries, entities come in, then even their regulators would have to expand, the regulation will have to expand to cover that product. And I think that should be the first place to start.
Okay, thank you very much, Leonard Silk. Sorry. Thank you very much, Leonard Silk. Jump to the next question. This is from Tohiba Muda. What effect, if any, can the UK Supreme Court decision in PACCAR, where the court rules that litigation funding agreement LFAs, which entitle funders to pay based on the percentage of any amount of damages recovered, constitute damages-based agreement (DBAs), and such LFAs are unenforceable? Have an arbitral award sought to be enforced in the UK, where the losing party argues the winning party has utilized third-party funding, offering a percentage of return to funder? Can such argument to resist enforcement fly, or will the court consider the law of the seat? This is a very long question. I don't know if you're still on, if you can access the Q&A. But do you want me to take that again?
I can. I've and I think it's I did. Okay. I don't know when he joined. I'd actually addressed that issue. I do believe I have. The Packer set the cat among the chickens. Packer remains the law in the UK today. And when you were asking about what the funders would have to consider, I mentioned the fact that they have to consider the law of the seat. The short answer to his question, and I hope I understood it properly, is that I do not think that any resistance to the application of PACA to an attempt to enforce in the UK, where the UK is the seat, would fly, because PACA is the law as of today. I think about March or February 2024, the UK Parliament was still mulling the question of rolling out legislation to nullify the effect of PACA and restore the status quo. Until that happens, or until the UKSC reverses itself, PACA remains the law. And that is why if you're looking to enforce in the UK, you must, in drafting your third-party funding agreement, consider that issue. Now, compare that to section 61 sub B of the Arbitration and Mediation Act of our own law. Section 61 talks about legalizes TPF for Nigeria's arbitration, and then that is A. Then B says, or Nigeria-related proceedings. So there's arbitration where Nigeria is the seat. Then there's Nigeria-related proceedings where, so the word Nigeria-related proceeding is where you are coming to enforce in Nigeria. You know, so these are the issues. If you're in Nigeria, it will be legal in Nigeria. But if you go to the UK under Parker, I'm not quite sure that the argument that anybody proposing will work.
Thank you very much, Leonard Silk. I'll quickly move to the next question. This is from Professor Wale Oluwayi, Senior Advocate of Nigeria. Professor Olawoyi wants to know if a third-party funding provisions could be a potential game changer for access to justice. However, there's the potential for misuse. Does the speaker consider this? Do you, Leonard Silk, consider the separate guidelines have to be put in place? And if so, whose responsibility would it be in our legal ecosystem?
Could you take that question again, please? Sorry, I didn't quite get you.
Yes, sir. Yes, sir. This question is from Professor Wale Oluwayi, Senior Advocate of Nigeria.
Oh, Prof, okay.
The third-party funding provisions could be a potential game changer for access to justice. However, there's a potential for misuse. Do you consider the separate guidelines? Do you consider that separate guidelines have to be put in place? And if so, whose responsibility would it be in our legal ecosystem?
So the first arm of that question, the answer is yes. It's a potential game changer. It is a game changer, actually, because it will widen the door to access to justice. I think it should go without saying that there's potential that a whole lot of issues that could be litigated and not litigation arbitrated, you know, because of the costs. People are not able to do that. So yes, it widened access to justice. In fact, left to me alone, I'm praying and hoping that that door will be, the TPF will be expanded to cover litigation. Okay, we can retain the spirit of maintenance and sham party, but abolish the thought itself, you know, and that can be done by regulation. Now, the second question is, whose responsibility would that be to evolve? So first and foremost, guidelines are necessary, okay? So that you can have, you know, one thing about guidelines is once you have these things, you have regulatory checklists to be able to judge a standard against minimum standard to judge the thing you're doing. So yeah, that's important. As to who can do that, personally, it's just that we have a very arthritic legislature. They are not nimble at all. Again, I give you an example of the UK. Parker came out only last year, and the UK Parliament is already discussing, you know, evolving legislation to deal with it. Okay, ours will take years. But so generally, I think the best case scenario for me would be that existing regulatory authorities, or as the VOS report suggested, is recommended to the EU, establish that member states, EU member states should establish independent bodies, okay, amongst the different member states that will be responsible for regulating this particular industry. It will not hurt us to do so. But even if you don't want to do so, we can expand. Again, I can't stop thinking about the CBN. Maybe create a particular department, okay, that will regulate that industry and then roll out guidelines. And that would mean amending the CBN Act or the BOFIA to empower the regulator to be able to roll out guidelines that any third-party funder, anybody who wants to play in that space can meet to be able to do that. So I think it has to be an independent body. The other thing too, as a secondary or maybe intervening while we wait for the ideal position, would be for the different arbitration bodies also to have their own ethical rules for people who would want to get that, you know. So you have my own the CIR. You also have the Nigerian the NICAP. You have all the different bodies, you know. But these ones having all these disparate, it will be good to have one central rule getting the entire thing. I don't know if that
Thank you.
addresses.
Thank you very much, Leonard Silk. I'm already pleading with our organizers to please give us 5 minutes. I hope this is granted. So I'll just take 2 last questions really quick before we wrap up at 3:05. So we have one from Ezewu Ejikeme.
Sorry, Amara, if I may quickly add, finally, with regard to that, still to that question, judicial intervention, as they keep coming along, judicial intervention will also do a whole lot, okay, in providing guidelines. Please go ahead. Apologies for the interruption.
Thank you very much, sir. So we have a question from Isa Zakari, and Isa wants to know how a funder will recover his fees, or rather percentage, where a party who engaged him refused to honor his obligations.
Okay, so that falls within the realm of contract. And you know what's even interesting? The interesting thing is that a TPFA, that's a third-party funding agreement, can also have an arbitration clause. So you might find a situation where
you have an arbitration within the arbitration.
You know, but obviously before you get to that point, you would have finished the arbitration that is ongoing. But it's a matter of contract anyway, if they refuse. Look, the more important thing for me, again, talking about guardrails, this immediately harks back to the question of guardrails, is that we've done this now. The AMA has done its own. The legislature and then the government needs to do more with regard to introducing necessary efficiency to our judicial system. We cannot enjoy the full benefits and the potential that this has for us in positioning us as a favorable and choice arbitration seat, at least in Africa, if we do not invest in putting efficiency into the judicial process. Currently, if you look at the spirit of the act, you notice one thing. The AMAT has tried to take arbitration from what it was from under the ACA, where it was no more than a glorified pre-litigation, pre-action process, where everybody is just waiting. Once the arbitral tribunal gives its decision, we will now make a race to the. So at the end of the day, what was designed to bring efficiency to the judicial process has now become a big clog, if you like. We need to do more. If Nigeria, but that is outside the scope of the arbitration committee. That one it's actually within the realm of government. That we need to do more to improve the efficiency of the system, because if a funder will still have to be bogged down on the enforcement front, then as beautiful as this particular provision is, it will not serve us it won't do us any good at all.
Thank you, Leonard Silk. We'll just quickly take one more question before we close. We have just 2 minutes. So we have a question from Nangwan Nanshan. He says, please, is the recovery of third-party fund realizable only if the claimant who uses the fund succeeds? If yes, what if a party who applies for third-party funding loses at the tribunal? How does the third-party funder recover its funds? I think this is okay. Now, where do you depose one? Sorry?
He doesn't. I'm trying to it's a long question, and because of the time. But
are you here, Leonard? Okay, so if the third-party funder can choose the counsel, so are you here with me on the question, or you want me to complete the question?
No, please finish. I thought I could.
Okay. So where do you depose? Where do you depose on affidavit in third-party funding in court or before the arbitral tribunal? Is there a punishment for perjury in such proceedings? Or what happens if the respondent fails to attend the arbitration proceedings, especially in the preliminary meeting where the fees are decided? Do you need the consent of the other party before you sit and use third-party funder. If the third-party funder can choose the counsel also, will that not encourage the practice of encouraging bribes and manipulation of the tribunal? That's the end of the question.
Amara, you can see that this is a bundle of questions. You did say we have we'll take two.
Let us see, just take one or two.
So just give him 1 minute.
So let me
1 minute.
I'll take one. Is the recovery of the fund realizable only if the claimant uses the fund, who uses the fund succeeds? The short answer is yes. There's a reason it's called a non-recourse debt. Not because there's no collateral, there's nothing. Your whole hope is on the success of the process. So that's the short answer to that.
Thank you very much, Leonard Silk. I can't thank you enough for such a wonderful session. Like I said, it's a whole lecture put together. Thank you so much for honoring our invitation. Thank you very much, sir. At this point, I'd like to hand over. Thank you, sir. At this point, I'd like to hand over to our host, the chairman of the Arbitration and ADR Committee for the NBA-SBL, Mr. Ladipo Oshueton, fellow of Chartered Institute of Arbitrators. Over to you, sir. Thank you.
Thank you, Amara. So I'd just like to say a very big thank you to our member, the Leonard Silk, for giving us time today during these holidays to speak so eloquently and so knowledgeably about this topic. As we can see, 60 minutes is not enough for us to do justice to this topic. We may have to divvy it up and attack several topics in more detail, maybe security for cause or other topics under TPF in more detail later. Thank you very much for coming. Thank you for speaking. I'd like to thank all the attendees. We had over 100 people at some point attending this webinar. I'd like to thank my good friend, Professor Wale Olawonyese, for attending also. I saw that he joined at some point. Thank you very much, Prof. I just want to quickly say that the Arbitration and ADR Committee, we've set up subcommittees. I'm saying this to all our attendees who want to take a greater part in the activities of the SBL. We have several subcommittees. The Programs Committee, which is, of course, designed to bring forth programs such as the ones we are currently having. We have also the Logistics Committee and the Publicity Committee. You can join any of these committees. Actually, it has closed, but I'm just saying if you really want to join, we only close it on 9th of April, but in the spirit of diversity and getting everybody to participate, let us, if you are interested, please contact our secretary. I think he's online here also, the secretary of the committee, and tell him which subcommittee you'd like to participate in. It's very important. You'll get much more benefit from joining the SBL if you participate in one of the subcommittees. So thank you very much, everybody, for joining. And thank you especially to our moderator, Amara, for doing such a wonderful job. Thank you.
Thank you so much.
Thank you very much. Yeah, thank you, everyone. Thanks to the organizers. Thank you, all attendees. Have a wonderful evening. And it's a wrap. Thank you very much.
Bye, everyone.
Bye, everyone. Thank you.
Bye, everyone.